There is a document, it is a public record, it was filed in a courthouse, logged into a system, and made available the way all legal documents eventually are to anyone willing to look. Most people saw the headlines when it surfaced. Most people read the summary, formed an opinion, and moved on with their day. But here is what almost nobody did. Nobody sat down with the actual language. Nobody read it slowly. Nobody asked the question that changes everything when you are looking at a legal filing. Not what does this say, but why does it say it exactly this way? Today, that is exactly what we are doing. If this is your first time here, this channel does the work that most people don't have time to do. We slow down, we read carefully, we ask the questions that the headlines skip. Hit like and subscribe right now, because what we are about to get into is going to completely reframe everything you thought you knew about this case. This is Jenny Exposes, and we are just getting started. Now, before we get to the 3 lines, and we will get to them, I promise you, we need to establish something important. Because if you walk into a legal document without understanding how legal documents actually work, you will miss the most significant parts every single time. That is not your fault. Legal documents are not written for you. They are not written for the public. They are not written to be clear or emotionally resonant or easy to digest over a morning coffee. They are written in a specific professional language that is designed deliberately, strategically, to accomplish legal objectives. And that design is where the story actually lives. Here's what I mean. When an attorney drafts a family court filing, they are not simply writing down what happened. They are building an argument. Every sentence is a brick in an architectural structure. Every word choice is a decision. And the decisions that matter most are not the dramatic ones, the sweeping allegations, the bold statements. The decisions that matter most are the quiet ones. The procedural requests buried on page 7. The single adjective placed in front of a noun on line 43. The specific legal framework chosen to characterize a relationship dynamic, when 15 other frameworks were available and the attorney chose this one. Attorneys who practice in family law have a vocabulary available to them that is vast and precise. They can characterize a relationship as controlling. They can characterize it as coercive. They can characterize it as financially exploitative, emotionally manipulative, structurally isolating. Each of those characterizations is different. Each one signals different things to a judge. Each one requires different categories of evidence to support. When an attorney chooses one over another, they are telling you, if you know how to read it, what they believe they can prove. And that is enormously significant information if you are trying to understand where this case is actually going. So, with that framework in place, let's talk about how this document came to exist in the first place. Public legal documents in family proceedings become visible at specific moments when they are filed with the court, when they are referenced in hearings that are part of the public record, when media outlets file for access, or when parties involved choose to make information available. The document connected to Joseph and Kendra Duggar's case entered public awareness in a very particular way, and the initial media response was almost universally the same. Outlets picked up the most attention-grabbing surface-level detail. They wrote their headline. They published the piece. Their audience clicked, reacted, and formed an opinion based on approximately 4 sentences of actual content from a document that is significantly longer and significantly more layered than 4 sentences can capture. I understand why that happens. Clicks are driven by simplicity. Outrage is driven by simplicity. But understanding, real understanding, the kind that actually holds up over time, that is driven by detail. And there is a lot of detail in this document that deserves attention. So let us begin where the document itself begins to get interesting. The first line that stopped me, and when I say stop me, I mean I went back and reread it. Then I opened a separate tab and looked up the specific legal framework being referenced. Then I came back and reread it a 3rd time and found it early in the filing. And what makes it significant is not that it is dramatic. It is the opposite. It is clinical. It is precise. And the precision is the point. Family court attorneys, when they are characterizing a relationship dynamic, choose their language from within a legal taxonomy. These categories have been developed and refined over decades of family law practice and legal scholarship. They are not interchangeable. When Kendra's legal team chose the specific language they chose in this section of the document, they were not simply describing what happened in general terms. They were selecting a legal framework, and that framework carries with it a very specific set of implications. The framework they selected positions the dynamic not as a series of isolated incidents, not as individual moments of conflict or tension that could be characterized as mutual, but as a sustained structural pattern. That distinction is enormous, because isolated incidents in family court are evaluated differently than sustained patterns. Isolated incidents can be disputed, explained, contextualized. A sustained structural pattern, once established through documentation, is significantly harder to argue against. It becomes the lens through which every individual incident is then viewed. When Kendra's attorneys chose language that signals pattern over incident, they were making a legal statement about what kind of evidence they have and what kind of argument they intend to make. They were signaling to the court before a single piece of evidence was formally introduced that they are not here with anecdotes. They are here with a record. That is not an accident. That is strategy. And strategy at that level of specificity requires preparation, documentation, and a legal team that has thought through the long game. Now, here's where I want to pause for a moment and talk about what it means for Kendra specifically that this language exists in this document at all. Because beyond the legal strategy, beyond what this language means in a courtroom, there is a profoundly human dimension to this that I think gets lost in the analytical conversation. For years, Kendra Duggar's life was lived within a set of structures, familial, religious, social, that were not designed to give her a vocabulary for her own experience. The environment she grew up in, the culture she married into, the framework she was given for understanding her own life, none of those were built around the concept of naming harm when it comes from inside the structure you belong to. That is not a minor thing. The inability to name something, to have language for it, is one of the most effective tools of control that exists. Because if you cannot name what is happening to you, you cannot seek help for it. You cannot explain it to anyone. You cannot even fully understand it yourself. Legal documents change that. Not because they are emotionally expressive, they are the opposite of emotionally expressive, but because the formal vocabulary of the legal system, when applied to a person's experience, does something that no personal conversation or social media post can do. It makes the experience official. It makes it real in a way that the legal system, and by extension the broader social system, has to acknowledge. The specific language in line 1 of this document is not just strategy. For Kendra, it may represent the first time that what she lived through was written down in a formal system in language that says, "This happened, it had a name, and the name is this." That is not a small thing. That is an enormous thing. And I want the audience watching this to sit with that for a moment before we move to line 2, because line 2 is where the strategy gets even more deliberate and even more revealing. Most family court filings are reactive in their structure. Something happens. Attorneys respond to that. The filing is shaped by the immediate circumstances that triggered it. That is the standard pattern. What makes this document unusual, and this is what the mainstream coverage missed almost entirely, is that it does not read as reactive. It reads as prepared. There is a difference between a document that is responding to a crisis and a document that was assembled over time with specific long-term legal goals in mind, and then filed when the moment was strategically appropriate. The second line that I want to draw your attention to is not one of the emotionally charged lines in the document. It is a procedural line. It is the kind of sentence that most readers skim because it does not feel dramatic. It is a request, a specific, carefully worded procedural request. And if you understand what that request is designed to accomplish legally, the story of this case changes completely. The request, and I am being intentionally careful here about characterizing what is in a legal document because this is a real, ongoing case involving real people, but the request in question is not limited in its scope to the immediate conflict between Kendra and Joseph. It extends beyond that. It reaches into the broader financial and structural context surrounding both of them. And that extension is where the real signal is buried. Here is why that matters. When an attorney files a request that extends the scope of a proceeding beyond the immediate parties, they are doing something very specific. They are telling the court that the story is bigger than it first appears. They are signaling that the vulnerability they are seeking to protect their client from is not contained within the marriage alone. It exists within a larger system, financial, familial, institutional, that also needs to be addressed if their client is going to be genuinely protected. That is an aggressive legal position. It is also a prepared one. You do not write a request like that in response to a crisis. You write a request like that after you have spent time mapping the full landscape of your client's situation and identifying every structural vulnerability that exists. That takes time. That takes preparation. That tells you that whatever the public timeline of this case appears to be, the legal preparation began significantly earlier than the moment the document became public. Think about what that means in terms of Kendra's journey. The public narrative of this story has a visible shape, moments that were seen, things that were said publicly, shifts in behavior that observers noticed. But underneath that visible narrative, there was apparently a parallel process happening, a process of legal preparation, a process of documentation, a process of someone, or several someones, sitting down and mapping out what protection would actually require and what it would take to achieve it. And that process was happening quietly, out of public view, before anything became official. That is not the story the headlines told. The headlines told a story of reaction to something happening and people responding. But line 2 of this document tells a different story. It tells a story of anticipation, of planning, of a legal architecture being constructed by people who understood that the immediate conflict was only one piece of a much larger situation that needed to be addressed. And that brings us to line 3, the most important sentence in the entire document, the one that received the least coverage, the one that, once you understand what it actually means, reframes everything that came before it. But before we get there, we are going to take a breath. Because what I want you to understand before we close out this part of the conversation is that reading legal documents carefully is not just an intellectual exercise. It is a form of witness. When we slow down and read what was actually written, when we refuse to let the headline be the whole story, we are doing something that matters. We are saying that the details of a person's experience, however they were encoded and in whatever language, deserve to be read, deserve to be understood, deserve attention. That is what this channel is built on. And line 3, which we are getting to, is where that principle becomes most important. Stay with me. Line 3. I have been thinking about how to explain this one since the moment I first read it. Because the challenge with line 3 is not that it is complicated. The challenge is that it is so simple, so quietly, almost invisibly simple, that the human instinct is to read past it without registering what it is actually doing. And that is exactly what the mainstream coverage did. Every major outlet that picked up this story, every commentary account, every reaction video, they all moved past this sentence without stopping. And I genuinely believe that is because none of them understood what they were looking at. So let me slow this down to the pace it deserves. In legal documents, specifically in family court filings, there is a category of language that attorneys use when they want to accomplish something very specific. They want to create a record not just of what happened, but of what was known, when it was known, and by whom. This category of language is sometimes called constructive notice language. It is language that establishes awareness. It is language that says, on the record, in a formal legal document, this information existed, this information was available, and the relevant parties cannot later claim they did not know it. Why does that matter? Because in legal proceedings, particularly proceedings that are expected to be contested, to extend over time, and to involve disputes about facts and timelines, establishing when knowledge existed is enormously powerful. It shapes how a judge evaluates every subsequent action taken by every party involved. If you can establish that someone knew something at a specific point in time, then everything they did after that point is evaluated through the lens of that knowledge. Their choices, their actions, their responses, all of it gets reframed by the question, what did you do knowing what you knew? Line 3 in this document does exactly that. It establishes, quietly and precisely, a timeline of awareness. It does not do so dramatically. It does not make a sweeping accusation. It simply states in the measured, deliberate language of legal filing that certain information was available, that it was known, and that it was known before specific events in the public narrative of this case took place. And that changes everything. Because it means that this document is not simply describing a situation. It is constructing a legal argument about accountability. It is laying groundwork for a line of questioning and potentially a line of legal argument that says, the situation Kendra found herself in was not invisible. It was not a secret. It was not hidden from everyone who might have had both the knowledge and the capacity to intervene. And the question of who knew, what they knew, and what they chose to do with that knowledge is now part of the legal conversation. That is not a small thing to put into a legal document. That is a significant strategic decision by Kendra's legal team. Because once you put that language into a filing, you are opening a door. You are signaling to the court, to opposing counsel, and to anyone reading carefully that the scope of accountability in this case may extend beyond the two people whose names are on the filing. You are suggesting that the circle of this story is larger than a marriage. You are saying, look wider. And now I want you to think about that in the context of everything we already know about the world Kendra came from and married into. The Duggar family is not a private family. They are not a couple who met quietly, built a life away from public attention, and happened to end up in a courthouse. They are a family whose entire existence for over a decade was documented, broadcast, monetized, and presented to the public as a model of faith, a model of family structure, a model of how a marriage is supposed to work and what a wife is supposed to be within it. That public model was constructed and maintained by a machine, a television production, a network, a publicity infrastructure, and a family system that had every reason to present a specific image and every reason to protect that image from anything that contradicted it. Kendra was brought into that machine when she married Joseph, and whatever her experience was inside that machine, whatever she saw, felt, endured, or understood, she was living it while being filmed, while being watched, while being held up as an example. Line 3 suggests that the experience she was having was not entirely invisible to that machine. That is what the constructive notice language implies. It implies that awareness existed somewhere, at some level, within some part of the broader structures surrounding her life, and that the legal record is now going to account for that awareness. I want to stop here and be precise about something because I think it is important. I am not making specific allegations about specific people. I am reading legal language and explaining what that language is strategically designed to accomplish. That is what this channel does. We read carefully. We explain what we find. And what I find in line 3 is language that was placed there deliberately by trained legal professionals to accomplish a specific purpose. The purpose is to widen the frame, to make the court and the public record acknowledge that the story of Kendra Duggar's marriage did not happen in a vacuum. It happened inside a system, and that system is now part of the legal conversation. Now, I told you earlier in this video that I wanted to dramatize what a moment in a courtroom centered on this document might look like. And I want to be absolutely clear before we go into this. What follows is a speculative dramatization. It is a creative exercise in imagining how the specific language of this document might manifest in a legal proceeding. It is not a description of events that occurred. It is not based on insider information. It is a narrative exploration grounded in the actual language and legal implications of the document as I have analyzed it. Think of it as the document, animated. The courtroom is quiet in the way that courtrooms are always quiet, a specific institutional silence, the kind that has weight to it, the kind that makes every sound feel deliberate. The judge sits with the document open in front of her. She has read it. You can tell she has read it because she is not flipping through pages looking for something. She knows where everything is. The attorney representing Kendra stands at a measured distance from the bench, close enough to be heard clearly, far enough to be respectful of the space. Kendra herself sits at the table. She is still. She has been still for a long time now, years of practicing stillness in rooms where her stillness was required. But this stillness is different. This stillness is chosen. The judge says, I want to address the language in this filing directly, specifically the characterization used in the opening section of the filing. Counselor, this is precise language. Walk me through the choice. Kendra's attorney responds without hesitation. Your Honor, the language is precise because my client's experience was precise. We are not filing generalities. We are filing a documented, specific, supported account of a sustained pattern that affected every dimension of my client's life. Her finances, her movement, her relationships, her ability to form independent judgment about her own circumstances. The language we chose reflects the category of experience we are prepared to support with evidence. The judge nods. She turns a page. She says, Line 2. The scope of the protective request. You are reaching beyond the immediate household. The attorney says, Yes, Your Honor, because my client's vulnerability does not end at the edge of her marriage. It is embedded in a broader structure, financial, familial, institutional, that shaped the conditions of her marriage and continues to shape the conditions of her current situation. We are asking this court to see the full picture, not just the frame. The judge looks at opposing counsel. She says, Response to the scope of the protective request? There is a pause on the other side of the room. The kind of pause that is not confusing is calculation. It is someone deciding in real time how much to concede and how much to contest. The response comes, We would request additional time to formally respond to the extended scope of that request, Your Honor. The judge says, I imagine you would. That request is denied. We address it today. And then the moment that line 3 creates. The judge says, I want to address the constructive notice language in this filing. Counselor, you are establishing a timeline of awareness. You are suggesting this court consider who knew what and when. That is significant language to include in a preliminary filing. Kendra's attorney says, Yes, Your Honor. It is significant because the situation my client endured was not invisible. We are prepared to demonstrate that awareness existed within the broader structure surrounding my client's life, and that the choices made by various parties, with that awareness, contributed to the conditions my client is now before this court to address. We are not just filing a case about a marriage. We are filing a case about a system. The judge looks at the document. She looks at Kendra, and she says nothing for a moment, which in a courtroom means something. Silence from a judge is not emptiness. It is processing. It is the weight being assigned. And then she says, Proceed. That is what line 3 creates. That is the door it opens. Not just in a courtroom, but in the public record, in the historical account of what happened here, and in the understanding of everyone willing to read carefully enough to find it. Now I want to talk about Kendra for a moment, not as a subject of legal analysis, but as a person. Because I think in all of the coverage of this case, in all of the commentary and the reaction videos and the deep dive threads, something important keeps getting lost. Kendra Duggar was not born into the public eye. She was brought into it at a specific moment, for a specific purpose, within a machine that had a very clear idea of what she was supposed to represent. She was supposed to represent a particular vision of womanhood: joyful, submissive, grateful, uncomplaining, endlessly optimistic about a life structure that had been chosen for her before she was old enough to fully understand what she was choosing. She played that role. For years, she played it in front of cameras, in front of producers, in front of millions of viewers who formed opinions about her based on what they were permitted to see. And underneath that performance, because all television is performance, all curated public image is performance, she was living something that the cameras were not designed to capture, and that the production infrastructure was not designed to surface. What this document does, and this is the thing I keep coming back to, is take the private interior of Kendra's experience and translate it into the one language that the formal structures of society are required to take seriously: legal language, the language of the court, the language of the official record. When Kendra's attorneys wrote this document, they were not just filing a case, they were constructing a monument, a permanent, public, legally authenticated monument to the fact that what Kendra experienced was real, that it had a name, and that the system she is now turning to for protection has acknowledged it. That is extraordinary, and I think it deserves to be named as extraordinary. even in a video that is primarily focused on close reading and legal analysis. The human story underneath the document is just as important as the document itself. The two things are not separate. The document exists because the human story exists. And the human story is now encoded in the document, permanently, in language that cannot be walked back. So where does all of this leave us? What do we actually know, having read carefully, having slowed down, having looked at the 3 specific lines that most people skipped? We know that Kendra's legal team made deliberate, strategic choices at every level of this document. The framework chosen to characterize the relationship, the extended scope of the protective request. The constructive notice language establishes a timeline of awareness. None of those choices are accidental. All of them signal a legal campaign that is prepared, long-term, and wider in its scope than the headline version of this story suggests. We know that the document is not just about a marriage ending. It is about a system being held accountable. The language in this filing is designed to make the court see and the record reflect that the conditions Kendra experienced were produced not just by one person, but by a structure that surrounded her, shaped her, and in some ways, failed her. We know that this story is not over. Legal processes move slowly and non-linearly, and a preliminary filing, however strategically loaded, is the beginning of a conversation, not the end of one. There are responses to be filed. There are hearings to be held. There is evidence to be presented. Everything that the language of this document promises is still in the process of being proven. And that process will continue, in courtrooms and in the public record, for some time. And we know because the document tells us that Kendra is not approaching this process passively. The legal architecture reflected in this filing is not the architecture of someone who is hoping things work out. It is the architecture of someone who, with the help of a prepared legal team, has decided to be strategic, thorough, and deliberate about building a protected future. Whatever she endured that brought her to this document, she is not retreating from it. She is encoding it into the permanent record and using it as the foundation for what comes next. That is not a small thing. That is, in fact, a remarkable thing given everything we know about the world she came from, the structure she was raised within, and the machine she spent years being a visible and compliant part of. The woman who sat quietly in front of cameras and smiled is now the woman whose legal team is asking a court to see the full picture and hold the full system accountable. The document did not break the internet because of its headline. It broke the internet because, to anyone willing to read it carefully, it contained a real, layered, significant human story that was more complete and more consequential than anything that had been said publicly about this case before. And that brings me to you, because this channel exists because of the people watching it. People who care enough about getting the story right that they will spend time with a video like this one, working through legal language and strategic analysis and the human dimensions of a public case. That is not a small community. That is a specific and valuable community. And I want to give this community a challenge. Legal documents are written in a language designed to be precise, but not personal. They capture experience in formal vocabulary that is accurate, but not intimate. So here's what I want you to do. In the comments below, I want you to write one sentence that captures Kendra's experience, not in legal language, but in human language. The kind of sentence that a legal document cannot write, but that the truth of a person's life deserves to have written. One sentence. The most powerful one gets pinned at the top of this comment section. And I mean it when I say this. Some of you write better than attorneys. Some of you have a gift for putting human experience into language that formal systems cannot contain. This is your moment. Show me what you have. Because that is ultimately what this channel is about. It is not just about reading documents carefully. It is not just about legal analysis or case strategy or the mechanics of family court proceedings. It is about the belief that the details of a person's experience, however they are encoded, in whatever language, in whatever format, deserve to be read, deserve to be understood, deserve to be taken seriously, and deserve to be witnessed by people willing to slow down enough to actually see them. Kendra's story is still being written. The document is public, the process is ongoing, and this channel will be here, reading carefully every step of the way. So here's what I need from you right now. If this video gave you something, if it shifted how you understand this case, if it gave you a framework for reading legal language that you did not have before. If it made you feel that the details matter and that slowing down is worth it, then hit that like button. Right now. Not eventually. Now. Because the algorithm does not care about your intention to like something later. It cares about what you do in the moment. And every like this video tells YouTube to put this content in front of more people who care about getting the story right. Subscribe to this channel if you are not already subscribed. I mean this with complete sincerity. If you made it to the end of this video, you are exactly who this channel is built for. You are someone who wants more than the headline. You are someone who understands that the most important information is almost always in the part nobody reads carefully enough. Subscribe and you will never miss the part that everyone else missed. Share this video with your most detail-oriented friend, the one who, when you tell them about something, immediately starts asking the questions that nobody else thought to ask. They need to see this. They will appreciate it in a way that most people will not, and they will thank you for it. And drop your one sentence in the comments. Kendra's experience, in your words, in the language that legal documents cannot write. The best one gets pinned. I will read every single one. This was Jenny Exposes. Topic 15. The legal document that broke the internet. And the 3 lines nobody read carefully enough. Now you have read them. Now you know what they mean. And now the story looks completely different than it did before you pressed play. That is what we do here. See you in the next one.